Good morning, everybody, and welcome to Real Talks, Dominate Real Estate. I'm Charlie Bengel.
And I'm Meaza. Grab a cup of coffee and let's make your real estate career better.
Good to see you, Eyerusalem, and I'm excited about our special guest this morning, Lem Marshall. But first, what's in the news today?
Yep. Well, homes are selling at the fastest rate ever recorded by Zillow. Homes are typically selling just 20 days after hitting the market, according to a weekly market survey published Thursday by Zillow. It's the shortest span ever recorded by the Seattle-based real estate tech company, and it's resulting in fewer price cuts and rising home prices. As surprising as it may have seemed at the time, sellers who forged ahead with listing their homes this spring were richly rewarded when buyers, buoyed by record low mortgage rates, flooded their listings with offers, said Jeff Tucker, Zillow economist. Now word is getting out that the housing market is on a solid ground, so more listings are belatedly rushing to the market, extending the busy spring shopping season well into the summer. The huge millennial first-time home buying wave is still cresting, pushing demand above what's still very limited supply, so sellers are likely to find eager buyers for months or even years to come. List prices were up 4.3% annually as of early July, according to the report, but have only grown 5.8% in the past 2 months, which signals a slowing down in price appreciation. Zillow's data also suggests sale price growth is likely to reverse course soon and balloon again, with new listings of high-end homes surging and raising the median price. In other news, the coronavirus pandemic cuts rent growth to a decade low. Back in February, just before the coronavirus hit the U.S. economy, rent growth for single-family homes had hit its highest pace in 4 years. Barely 3 months later, that growth plummeted to a decade low. Single-family rents grew just 1.7% annually in May on a national level, according to CoreLogic. That's the slowest growth rate in nearly a decade and a little more than half the growth with these 12 million rental homes we're seeing the year before. Single-family rentals make up 35% of all rental housing in the U.S., and these homes are valued at more than $2.3 trillion. Single-family rent growth slowed abruptly in May as the nation felt the full impact of the economic crisis caused by the pandemic, said Bali Boisel, principal economist at CoreLogic. Some metro areas, especially those that depend on tourism, were hit hardest by job losses. With unemployment rates predicted to remain high through the end of the year, we can expect to see further easing in rent growth as the economy struggles this year. The slowdown in rent growth was most severe at the high end of the rental market, while lower price rentals saw rents going up more markedly. That is likely because the demand for high-end rentals has dropped more dramatically than demand for lower price properties. Charlie, what's going on with rates?
Thanks, Eyerusalem. Rates are pretty steady over the last week. Excellent rates, 30-year fixed rates. This is conventional 3 1/8, 30-year jumbo, 2.875, FHA 2 3/4, and VA 2 3/4. I also had a friend, Eyerusalem, who locked in a conventional refi rate of 2.99% in DC yesterday. So our good rates have also extended to the refi market. What's going on with real estate stats?
In the last week in the Hampton Roads, we saw 798 new listings hit the market, 909 properties go pending, and 795 properties sold. In the last week in the Washington metro area, within 30 miles of the White House, we saw 1,366 new listings hit the market, 2,036 go pending, and 1,601 sold. Back over to Charlie with our special guest.
Thank you, Eyerusalem. I would like to welcome Lem Marshall to the show. Many of you watching have seen Lem live, and hopefully we will get back to that sooner rather than later, live and in person. Lem's been a real estate attorney in Virginia for 35 years. He's the former general counsel at the Virginia Association of Realtors, was a member of the Virginia Real Estate Board, and has represented real estate companies and licensees throughout his entire career. And how I also describe you, Lem, is if you're an agent and you really find yourself in trouble, that's who I'm going to refer you to. So without further ado, welcome to the show.
Well, thank you, Charlie. It's nice to be here. I appreciate the invitation. This was the first opportunity I had to meet Eyerusalem. She's aces, no question.
Well, thank you. People love Eyerusalem, and she loves compliments. See, there you go. So I appreciate that, and I appreciate all the hard work that she puts in to make this show what it is. So lots of new real estate laws in Virginia that were effective a few weeks ago on July 1st. Where do you want to start with those?
Well, I thought I'd just start with some that we can hit quickly and then move on. But I want to start by saying that because we have a limited time here, there's going to be a lot we're not able to discuss. I'm going to be hitting the high points on these things. If you have questions about these, I refer you back to Charlie or Eyerusalem. We can all put our heads together to try to handle any questions that your viewers have.
Great.
So let me just start with some of the things that that everybody's going to need to know about or may want to know about. And I'll go through some of these pretty quickly. For example, the rules in Virginia have been liberalized regarding military and spouses becoming licensed. This has been a big issue across the country. So now we have an expedited procedure for licensure of someone who's already licensed in another jurisdiction. They get transferred to Virginia, or a spouse is the licensee, or now to a neighboring state of Virginia. If those states have equivalents in their education and coursework and so on, their expedited licensure here will occur. A couple of business issues need to be aware of. Starting January 1st of 2021, can't be on your cell phone by hand in your car. Can't have it in your hand. They start at $125 fines, move up to $250 for each subsequent fine. You're going to have to use hands-free technology as of this coming January 1st. I know that's a pain to a lot of people, but it's important, unless it's an emergency. Otherwise, pull over if you have to use a.
So is this a primary offense, Lem? Will they be able to stop you just for this, or is this one of these funny secondary offenses that Virginia is always trying to do?
It is a primary offense.
Okay.
That means it doesn't have to be associated with speeding or something like that. They can see you on your phone and pull you over. Also, worker misclassification. You know, there's been a big dispute around the country over Uber and Lyft and temporary folks working for hotels and so on. In many cases, these things are pushed by unions, but they're also pushed by local governments and state governments for tax purposes. Worker misclassification, what I'm talking about is that person who acts as your assistant or a closing coordinator or whatever. If you are considering that person to be an independent contractor, you better be right. What the new law says is that you should consider that such assistants are independent contractors, and then you apply the test under the Internal Revenue Code. You can find that test for independent contractors at irs.gov to search, and it'll pop up. It's about a 20 to 25 part test. These are questions you ask. Do you pay them a regular fee? Do you dictate their hours? Do you provide the means by which they work or the tools of their trade? And so on. If you classify them as an independent contractor, which means you don't have to withhold tax and pay the relevant portions of the unemployment tax and so on, if you do that wrongly, you're in for a lot of trouble. The statutes that were enacted, there were several, also allowed them to sue you. The independent person misqualified can bring an action against you to force you to pay the taxes that they would have had to pay, the contributing part of FICA and so on. So you've got to get those things right.
Yeah, I suspect that this is a big deal for realtors that have not done it the right way. They have assistants, they're paying them, you know, just as a 1099 instead of, you know, get with a payroll company, do it the right way, right? This is not expensive to do it the right way, and to be sued over something like this or to have a complaint filed, I think would be not just stressful, but, you know, monetarily very unpleasant.
That's exactly right. This is especially going to affect teams. So some of your teams that are more active are going to see heightened scrutiny.
Okay.
Also, the calls we make. If you're making a call soliciting business, or if you're having an assistant do that on your behalf, now the law has been extended. You don't have to make the call if it's done on your behalf. If it's a text or if it's a call to a Virginia cell phone, and that person's on the do not call list. 500 for the first, 1,000 for the second, 5,000 for all subsequent such calls. It doesn't even have to be just a Virginia area code. It could be a phone that is used or that is present in Virginia, but they've kept their out-of-state cell phone number. That's common. All right, so you better check the do not call list if you're going to have solicitations made by text or by phone to cell phones as well.
Okay. And by the way, for RE/MAX Allegiance associates listening, the do not call list is available on WorkSmarter. I believe it's under resources. So that is there for you. You can run the numbers. Go ahead, Lem.
All right, a few things having to do with POAs and condos. I'll just mention them real quickly. One that's important, the 3-day rescission period that has been written into the law has been amended. It can now be extended for up to 4 days, an additional 4 days, nothing more than that. The statute is quiet about whether that can itself can be given up by the person who benefits it. The regular 3 days cannot be waived, but they can be extended for up to 4 days. So if you want to do that in trying to work out some problem with the package or other problem with the contract, you may extend it for up to 4 days, but no more. Let's talk about some of the fair housing issues here. The main thing is the source of funds, for our purposes, source of funds is now a protected class. And what that means is, most importantly, Section 8 housing, for example. If the money comes from any subsidy program, whether it's administered by the government or not, then the law provides that you may no longer say no to them because of the source of the funds. Now, there are two exceptions here. One is that the trigger is increased. The fair housing, the VRLTA was changed, as you know, some years ago to provide that it went from more than 4 units or 10, depending on counties, cities, et cetera, to more than 2. This now is applicable only if you own or have a 10% interest or more in more than 4 rental units or properties that are held out for rent, okay? And the second exception is that if you don't get proof of funds from the source, the government or whoever else is providing them, within 15 days, you may terminate the application. So that's a balancing act. You can't say no because of the source of the funds, but you don't have to wait forever for a government to tell you that they are qualified. You can go ahead and lease the apartment to someone else.
Okay.
Sexual orientation and sex and gender identity are now protected status, as is the status as a veteran. Okay, so you can just add those to the list, and this isn't just in fair housing, but also in public accommodation, employment, contracting, apprenticeship, banking, insurance, all these things. They are now broadly considered protected classes throughout Virginia.
So the theme in Virginia is just don't discriminate, period.
That's right.
Yeah.
That's right. That's exactly right. Now, let's talk about some things that are going to be of special interest to your property managers. The first thing I would note is that under the VRLTA now, we know that if money is being held in escrow, if you get a security deposit, for example, that security deposit must be held in an interest-bearing account by the agent, unless it's otherwise agreed in writing. So the parties can agree that the landlord will hold the money, for example, in which case it doesn't have to be in an interest-bearing account. They have to pay interest on it according to the statute, but we know that interest is effectively zero.
Okay.
So now that same rule has been extended to rental payments. Now, most property managers do have a separate rental income account, escrow account, but it's surprising how many times the check will be made out to the company and they'll just take it into their operating account. You can no longer do that. All right. You're never supposed to have done that, but now it's technically illegal to do that under the act. And if it's discovered for any reason, there's another complaint and they're looking at your records and they notice that this happened, they'll tag you for that as well.
Okay.
That money must come into your rental escrow account unless otherwise agreed in writing by the parties. You all can agree that the check goes directly to the landlord, all right, or that it comes to your operating account. But I wouldn't do that regarding your operating account. If it comes into you, put it in your rental escrow account, or have it go directly to the landlord and provide specifically for that in the lease. All right. Also, if you're considering somebody, we know there's special treatment under the Act for victims of spousal abuse, or what they call family abuse under the Act. That now, the protections have been extended to this extent. You may now, or you must now, consider that an otherwise qualified applicant who is only not meeting the qualifications because of a ding on the credit score related to the family abuse, you have to take that family abuse into account now. All right. The statute is silent, or it doesn't give us much help about how you find this stuff out. But if the applicant says, well, my credit got affected because my husband was abusing me and I missed work, or I missed some payments, or whatever it might be, you have to take that into account. If they would otherwise meet your requirements, you may not refuse to lease to them.
Okay.
Now this next one is important. Now, when you sign a lease, if you're under the VRLTA, you must give tenants a statement of their rights and responsibilities as promulgated by the Virginia Housing and Community Development, the Department of Housing and Community Development. That statement of rights and responsibilities is available at the DHCD website, but I have printed it out and sent it to Charlie in Eyerusalem. I understand it's going to be posted on your Facebook page. It can be downloaded. You must give that to them, and there is a second form that comes with it that the tenant has to sign acknowledging receipt of the tenant's rights and responsibilities. All right. So from now on, get that done when you take a lease. Now, this bill went into effect January 1st. So it's possible that some of you out there may have taken a lease effective January 1st, but didn't know about this and didn't get it. Well, don't worry to this degree. First, the fact that you didn't get it doesn't invalidate the lease. The lease is nonetheless perfectly fine. But your landlord can't bring an action to enforce a default under that lease until the landlord, until you have given them this form. So if you've got anything that falls in that 3-week plus period, print that form out, get it to the tenant, get them to sign that acknowledgement of receipt, put it back in your file, and you're good to go. The bill gives you 1 month to comply with this, 1 month after the lease is signed to comply. So you've only got about 8 or 9 days left. So go ahead and get those things done on those few leases that are out there like that.
Can you remind the group one more time the difference and the trigger between a common law lease or situation and the Virginia Residential Landlord and Tenant Act?
Yes. You're under the VRLTA as a matter of law if the owner owns more than 2 units, rental units in Virginia. All right, it's very simple. It used to be more than 4 in any county or in any city, or more than 10 in any county except Henrico and Fairfax.
Okay.
But now more than 2, and you're under the Act. You can opt out of the Act if you're not. You can opt into the Act if you have 1 or 2, but if you're more than 2, you're under the Act and may not opt out.
Do you recommend the common law lease or a Virginia Residential Landlord and Tenant Act lease?
No, I'm ordinarily, I think, it's good for people to have the ability to do what the parties want to do.
Mm-hmm.
But I pretty firmly believe that the VRLTA is the way to go, even if you have the choice, for a couple of reasons. First, the judges are familiar with it. And second, it's pretty darn friendly to landlords. Your clients aren't going to find it as burdensome as you might find it in some states. The law regarding the rights of tenants and landlords is pretty even-handed. and it puts down a schedule that is very good for your landlords to know and to follow. It just avoids all the kinds of problems that can come up if they're just hoofing it under the common law regime. So I pretty much recommend that.
Okay, awesome. And then the document that you were speaking about a minute ago, that can be downloaded. The instructions are, in the comments, so people can just click that link. Oh, there it is again. Thank you, Eyerusalem. So they should be good to go there, Lem.
Good, good. Now, if your tenants have rent assistance, you can't bring a notice of termination. You send a 5-day pay or quit or whatever. It must be accompanied by, or it must have on it whatever kind of notice you send. The Virginia Legal Aid website and phone number. That's valegalaid.org, and the number is 866-LEGAL-AID, LEGLAID. Okay, but they're available at the Legal Aid. Just Google Virginia Legal Aid, and you'll see their website and their phone number. They must be in the same font as everything else in the notice, giving the tenant information about how to contact legal aid when you're threatening to boot them out. Okay. Now, security deposits, a little change there. We used to have a regime that had to be returned within so long after the termination of the lease. Well, now landlords have a little more flexibility. It's a little better for landlords. The rule now is the security deposit must be returned on the later of termination of the tenancy or the tenant vacates. Okay, now that matters. Let's suppose the tenant vacates early, all right? Then the later of the end of the lease and the tenant vacating is going to be at the end of the lease. So the tenant leaves 2 months early. You have to return it within the statutory period after the end of what would have been the termination of the lease, not when the tenant vacates. On the other hand, so the landlord hangs on to the money longer to be sure everything is fine. Suppose the tenant holds over for 2 months. You don't have to return it with the trigger being the end of the ordinary lease and the beginning of the common law month-to-month lease, but when the tenant vacates. So you can hold it for that 45 days after the tenant has vacated. All right, so this is beneficial to landlords. So you do have that flexibility. There's a change in damage insurance. I don't know how many landlords require tenants to have damage insurance. Mostly they have lessee insurance. It's not really damage insurance. But if you do require damage insurance, the damage insurance cannot exceed more than the security deposit would, which is 2 months rent. Okay, so you can't make them buy something that would cost more than a security deposit would have cost. Now, here's another one that's interesting. The late fee charge is now limited to 10% of the rent or 10% of the balance owed, the periodic rent or the monthly rent. You got a rent of $2,000 a month. They're late in the payment of any of that rent. You can charge them 10%, up to 10% of that $2,000. But they give you a check, a timely check, but it's only $1,000. And the rest of it comes later. You can only charge them the 10% on that $1,000, not on the entire $2,000. It used to be you could charge them on the entire amount, or at least that was common practice, and now that's no longer permissible. Tenants now have the right to remedy by repair. If the landlord is given notice of problems affecting health or safety, fire, rodents, no water, things like that. If the landlord doesn't remedy within 14 days, the tenant may hire someone to remedy. Can't do it himself. Got to hire a licensed contractor to conduct the remedy. Give the landlord notice, then they can hire somebody to come do the work and not just dun the landlord for the payment, but deduct their next rent payment by the amount that they paid to have the work done. The amount that they can spend is limited to the greater of 1 month's rent or $1,500. So if your rent is more than $1,500, you can do up to that 1 month, say $2,000. If your rent is $1,000, that's the most. Then $1,500 is the most you can do. Okay. Now, substantial changes in the Residential Property Disclosure Act. And I'm not going to try to tell you all the different things that are now in the act, marine clays and so on. What I do want you to know is that before, the notice you gave would tell the tenant that you should check out what's on the VREB website. There's a form on the website. Check that out for all the information about what I'm not telling you, or information about that is available regarding the condition of the property and so on. That no longer works. You now have to give them what you could have earlier directed them to go find for themselves. So now there is a form at the VREB website. Just go to dpor.org, dpor.virginia.gov, click on the real estate board and go down to forms. There's a separate category for disclosures, and you'll find that form there. But that must accompany now the disclosure form that you give the tenant, the purchaser, early on in the transaction. One thing I'll mention, it's not likely to come up a lot, but before, you didn't have to tell them about stormwater detention. That was one of the stormwater detention facility was one of the things that was listed. We're not telling you about the following things, and that was a list as long as your arm. And stormwater detention was one of those things. We tell you to check it out for yourself. Well, now, if you know about a stormwater detention facility, you got to disclose it.
Okay.
You can no longer say we're not saying anything about it. You can still say that about a roof that's all shot. We're not saying anything about it, but you can't say that about a stormwater detention facility. But you need to be sure that you've got the right forms. So go to the DPOR website, Real Estate Board, Forms, Disclosures, and be sure you're using that right form. Now, regarding the coronavirus and things that have happened in that regard, a couple of changes. First, for those of you in Northern Virginia, this may apply if the federal government shuts down. There are protections to tenants who are employed by the federal government, or homeowners who are employed by the federal government. Tenants, if they can provide written proof that they are not receiving their wages, they've been furloughed or not getting paid because of a government shutdown, they can get a 60-day continuance on the unlawful detainer, the eviction notice. And the same on a foreclosure for an owner who is in that category, has been laid off by the federal government. As for the state, now you have a 30-day period. If a state shutdown, if you can show that a state shutdown has led to your not being paid, it doesn't tie it to being employed by the state the way the federal government is tied.
Okay.
Okay. But if you can show that your business shut down because of the coronavirus in Virginia, you've got an extra 30-day stay on unlawful detainer eviction or on a foreclosure action. Okay. And these were extended by the governor in emergency legislation in April of this year. So they've actually been in effect for a while.
Okay.
Now, I guess the last one I'll mention has to do with ReSPA. ReSPA is the federal statute that prohibits, among other things, that prohibits referral fees to non-licensed sources. So an agent who gets a referral from, say, me, I'm not licensed, but I refer someone to you. You may not pay me anything of value for that referral. That's a violation of ReSPA. Who can enforce that? Well, if the real estate board finds out about it, they will enforce it because it's a part of the real estate board regulations. They specifically refer to ReSPA and generally to violation of federal laws affecting the practice of real estate.
Okay.
But if the real estate board never hears about it, or if for some reason nothing happens in that regard, who can bring an action? Or who can bring an action against the other half of the equation? Me. I'm not a licensee. The real estate board has no jurisdiction over me. Well, now the State Corporation Commission, if they find out about it, they have independent enforcement authority against your clients who get paid an illegal referral fee, or third parties who refer business to you, or anybody who takes an action in violation of ReSPA. In addition to the federal fine, $5,000 under the Virginia statute, $5,000 per violation. Under the federal law, it's $11,000 per violation. Okay? That's what I wanted to talk about, Charlie, and it looks like we're right on the button. Do you, anything you want to raise?
No, I think we're good. I was hoping to get some questions in the comments. That doesn't look like that's happened. So if anybody watching has a last minute question, throw it into the Facebook comments. I thought that this was a very thorough review for the 20 minutes that we had together. We'll have to have you back on another show, or maybe do a webinar with our associates to allow them to ask questions, since I don't know when we're going to be able to meet in person again. It's not looking good for this year. So in the meantime, it's always good to see you, Lem. Appreciate your service to the industry, and stay safe and sane. And I'll throw it back over to Eyerusalem.
Thank you so much for watching. And as always, we are here to make your career better.
Take care, everybody. Have a good day. Thanks.